Well, here I am to talk to you about another subject matter case, and this is Goldcorp Corporation Limited, 1995 square brackets, one appeal cases at page 74. And I've got a visual aid. I've liberated B.A. Baracus's gold collection, as you can see, and that's important because, of course, gold is the subject matter of the case. Here we've got lots of different carats, different types of gold, and the facts of the case are quite similar in the sense that prepaying customers purchased interests, unallocated interests though, in gold bullion which was passing through the company, now a hopelessly insolvent New Zealand company, which was Goldcorp Exchange Limited. So of course, on the advent of insolvency, a battle for value ensued between those prepaying customers who thought they had specific gold allocated to them pursuant to documents that the employees of the company had drafted. So it's that group, prepaying customers on the one hand, versus the bank on the other, who was represented, interestingly, by Jonathan Sumption QC, as he then was, now of course Lord Sumption in the UK Supreme Court. And he, Lord Sumption, Jonathan Sumption QC, was arguing that pursuant to an equitable device of the charge, so floating charges for example, the bank had a better interest than could be asserted by those prepaying customers. So to what extent, in terms of subject matter, has this gold been allocated to specific customers? Is it clear enough to be certain for there to be a trust? This question goes right up through the appellate court structure in New Zealand, and then eventually comes over to the Privy Council, where Lord Mustill and his brethren have to consider these issues. And indeed the Privy Council held that there is no legal interest. The documents that I've referred to that the employees drafted weren't sufficient to show that, and similarly there was no equitable interest either. And that's because the ability to ascertain which specific element of the bullion, so which part of this gold, was sufficiently allocated to a given customer was too uncertain. There was uncertainty of subject matter in the sense of that unallocated, unascertained bulk of gold, the bullion that was passing through the company's possession at any given time. It seems it's okay for a floating charge to operate in that way, Lord Sumption's argument with that equitable device, but that it wasn't okay, it's not sufficiently certain for a trust to be able to be engrafted on that subject matter in that same way. So those prepaying customers, unlike in cases like Cayford, miss out. And they're not successful with their arguments. So from this collection of gold, I better return it to B.A. Baracus before I get in trouble. I bid you goodbye. So, goodbye.